We'll get started as we got a pretty full pretty full agenda today. So welcome everyone. This is our annual Multnomah Group's annual regulatory update. This is something that we've put out for several years. This is the fourth time that I've had the opportunity to work on and present this. The purpose of the annual regulatory update is to really sort of look over the last really 12 to 24 months at sort of the regulatory, legislative, and sort of litigation landscape, primarily as it relates to retirement plans. Just for anyone who might not be familiar with Multnomah Group, we recently celebrated our 20th anniversary. We are a full-service retirement plan and investment consultants. We really support clients in all aspects of managing their retirement plan, whether it be investments, plan design, vendor management, and we currently have 176 clients with over 289 plans and $34 billion in assets under advisement. My name is Greg Johnson. I'm a senior consultant at Multnomah Group and the director of our ERISA Technical Services Committee. I'm joined today by Candace Finn, senior investment operations analyst and soon to be law school graduate. So thank you for spending some time with us today. As I put the report together, you sort of reflect on what the main themes are. And I would say in the previous 2 years, we spent a lot of time talking about Secure 2.0 and the legislation and sort of how it was going to be implemented. And there's certainly some of that in there today. But really, as I went through, especially when you look at the IRS and the DOL sections, the DOL in particular, this year's update seems to have shifted quite a bit from regulation to litigation. The DOL, and I'll talk about it later, but finds themselves a defendant in a couple cases trying to defend some of their rules. Even when we talk about some of the defined benefit plans, there's some litigation focus there. So overall, litigation has actually gone down a little bit relative to some other years, but I think we're really seeing some shifts in the type of cases and really the way that plaintiffs are presenting their arguments so that they can survive, really. So we'll talk a little bit about all of that. But I think we wanted to start with the legislative update. And, to be honest, there wasn't a lot of new retirement plan legislation. But I thought it might be worthwhile to just take some time and talk about, whether, sort of the state of retirement and what the role is of government, both state government and federal government. The one interesting thing about retirement legislation, there's not much that gets bipartisan support these days. But one thing that does seem to get bipartisan support is the fact that there is an issue relative to Americans' retirement savings. Now, there is not bipartisan support on what the solution is, and we'll talk about that a little bit. But really, there is an issue approaching us, and it is a retirement crisis, and I think both sides agree that something needs to be done. Again, what that solution is may differ, but so why is there a retirement crisis looming? Well, two reasons: access and use. So if you look at the charts on the left, they talk about access. And the first one is civilian workers with access to a retirement plan. So currently, and this is from the Bureau of Labor and Statistics, 73% of civilian workers have access to a retirement plan. And I mean, on its face, that doesn't seem that bad, right? 3 out of 4 people all have access to a retirement plan. But the next chart shows that only 56% of those with access are actually participating. So, I'm not a mathematician, but I think some simple math suggests to me that means over 50% of Americans either don't have access to or have access and are not participating in their plan. It gets even worse when we look at small employers, and small employers are defined as 100 employees or less, where only 57% of the small employers offer a retirement plan. So, there definitely is an access issue, but there's also a use issue. And if you look at the average retirement savings by age, maybe focus on the 65 to 74 categories in the next 2 charts, you can see the average retirement savings for a 65-year-old is around $610,000. And, again, I think on its face, you look at that and you think, well, that's pretty good, $610,000. But if you plug that into one of the many retirement calculators out there, you'll see that if that individual with $610,000 were to withdraw $50,000 a year, they would use up all their money in about 15 years. Now, keep in mind, the general rule of thumb on retirement withdrawals is probably 4 to 5%. That 50,000 would be 8%. So that would only last 15 years in retirement. The real issue, though, is when you look at the median savings by age, because there you see 65-year-olds only at $200,000. So, comparing the average and the median, the average is so much higher because you've got a lot of people with very large account balances. So I think when you look at the median account balance, it gives a little better picture of where the average American is. And looking at that $200,000, if you did the same 8% withdrawal, which would only be $25,000 per year, that would only last 9 years in retirement. So to put it in perspective, the current average age of an American who reaches age 65 for women is to live another 22 years, and for men is to live another 19. So in both these scenarios, the individual clearly has not saved enough for retirement. So what are the solutions? In the absence of any wide-ranging federal solution, many states have tried to pass or have passed legislation of their own to try and address this issue. And really what they're focusing on is just the pure access issue. It is true that this is one of the areas that does not receive bipartisan support. It's no coincidence that all these states here do happen to be blue states that have passed these types of solutions. You've got 11 states that have active plans in place. Another 9 states have passed legislation that will enact a solution. Most of the plans are pretty similar. What they say is if you're an employer with 10 or more employees and you do not provide a retirement plan, you have to give your employees the opportunity to contribute into the state-run IRA plan. So, I did have someone ask me once, well, how does that solve anything? Because everyone already has access to an IRA. I mean, anyone can open an IRA if they want to. So how does this help? The one thing I'd say is it takes some of the complexity and some of the factors that maybe keep people from participating in an IRA, such as sometimes it's difficult to figure out which company am I going to invest in. Also, when you're investing in an IRA, it's pretty easy to get to the end of the year, and if you're going to make your $1,000 contribution, to decide there's something else I'd rather spend on that. So I do think it opens up an easier pathway for people to save for retirement. But one of the arguments against, not really argument against it, but one of the reasons that this is somewhat problematic is it's not very consistent and it doesn't have broad coverage across the United States. But this is sort of the one solution that we are seeing. I think the next question, though, is what about a federal solution? And a Democrat, Richard Neal from Massachusetts, in February introduced a bill called the Automatic IRA Act of 2024. And this is essentially a federal solution that mirrors what most of the state solutions are. Mandatory for employees with more than 10 employees that do not currently offer a plan. The big difference here, though, is it uses an auto-enroll feature. So it introduced a 6% default deferral rate that increases to 10% over 4 years. And, the one thing that I know from just watching all the defined contribution plans that I work with, there is the access issue. But I don't think there's been anything that's had a bigger impact on getting people to participate, so the use issue, than auto-enroll and defined contribution plans. I mean, it's not uncommon to see a plan that's being used at a 50-60% rate go up to 96% after auto-enroll is put in. And so, forcing people to participate, they always have the opportunity to opt out. But the fact of the matter is inertia does sort of keep them in the plan. So I think that's the biggest difference here. This isn't going to pass this year. This probably have to be brought up a couple more times before you see a solution like this in place. But I think it should also, Secure 2.0 also had some federal legislation that does address both the access and the use issues, because I think some are under the impression that the federal government doesn't care about this and isn't passing any laws to try and solve this problem. But Secure 2.0 did have at least three provisions that I think impacted. And the first is the access. So tax incentive for small employers who establish a plan who don't have one. They get a $5,000 tax credit for 3 years. And then as far as the use piece, all new plans, this is true today, all new plans of any size. So if an employer shuts down an existing plan and replaces it with a new plan, you are going to have to include auto enroll at 3% and auto escalate at 1% up to 10%. So that certainly addresses the use issue. In addition, another benefit that'll be rolled out in 2027 is a change to the savers credit, which allows lower income workers will actually be eligible to receive a $2,000 governmental contribution into their employer's retirement plan. So there is some activity taking place on the federal level to try and address what I believe is truly a looming retirement crisis. Now, I think if you're on this call, you probably already have a plan. So you're like, well, why does this matter to me? But in reality, if we get into a position where Americans in large numbers are not able to fund a successful retirement, it will ultimately become all of our problems. So that's just sort of an update on where we stand sort of as the retirement industry in general. There was some legislation that has been passed, though, relative to collective investment trusts. And I'll let Candace speak a little bit to that.
Yeah, so the final part of the legislative section relates to CITs and 403B plans. We're now at a point where it's not really a matter of if, but when the bill will be pushed through. So it's actually been passed in the House and it's currently being reviewed in the Senate. So we're waiting for it to pass in the Senate. But as I said, it's kind of more as an if, not a matter of an if, but as a when. And, there's not really any reason that this should not move forward. Originally, this started out with Secure 2.0, which included legislation allowing 403B plans to use CITs, but it didn't really include the necessary changes for the Officer of Comptroller and currency offices. So CITs actually aren't regulated by the SEC. They're regulated by a different entity. So since this is already available in 401k plans, this bill is really just bringing the Secure 2.0 provisions to fruition. And as I said, it's really not a matter of if, but when. So looking at the pros and cons here, the pros are available in 401k plans. They offer the same investment strategy at a lower cost, especially in this era of scrutiny for focus on investment fees. And then they may invest in alternative investments. So, there's that potential for customization here where similar investments could be offered, but they're not quite the exact same as the mutual fund. Greg, why don't you expand on that a little bit?
Yeah, I think that's probably the newest thing that we're seeing. Traditionally, CIT was just essentially a mirror of a mutual fund, holding essentially the same investments just at a lower cost. So maybe you can get the investment into your plan for 1 basis point lower than what the mutual fund costs. But I think this is an area that we're really going to see quite a bit of development. I think we're starting to see some new target date type default options that are including some different types of investments like fixed annuities in there. I think you can also see some CITs rolling out that have maybe a private equity sleeve. So the world where CITs generally just mirror a mutual fund, I think is going to change in the next few years. So it's definitely something we're keeping an eye on.
Thanks. So, reviewing some more of the cons. So there's an asset threshold for eligibility. When I'm working with 401k plans to get this put into the plan, I usually have to go through the amount of assets within the plan as well as those that might be moving into it. And that can kind of have some complexities to get that approved by the fund manager. Additionally, it's complexities with liquidation if the plan sponsor removes the CIT. So since this is done through trust paperwork, there are typically different liquidity options in a typical mutual fund. And lastly, the cost and complexity of the adoption of the trust agreement. So as I mentioned, CITs require trust paperwork, and that can be extensive just to set up the CITs in the retirement plans. I mean, we've seen typical fund changes take much longer sometimes with just getting the plan sponsor to get the CIT paperwork together.
All right. So that's really the legislative portion. The next thing we're going to move into is the Department of Labor update. And, I said at the beginning, focusing less on regulation this year and more on litigation. And that's certainly the case for the Department of Labor. We're going to talk first about a couple rules that they've implemented that have been challenged pretty significantly. The first is the fiduciary rule, and the second is the environmental, social, and governance investing rule. So let's start with the fiduciary rule that was updated and rolled out earlier this year. Just as a reminder, there was a previous fiduciary rule that was struck down by a court back in 2018. There's definitely been a lot of people lining up against the new fiduciary rule. So first, let's just start with what it is. Fiduciary rule says a financial service provider is an ERISA fiduciary if the provider makes an investment recommendation, the recommendation is provided for a fee, and the provider holds itself out as a trusted advisor by stating it as acting as an ERISA fiduciary or making the recommendation in a way that the investor would believe it is being made in their best interest. So that's the rule. But what does the rule really mean? I think that the biggest part of the rule and the reason that it's gotten the most pushback is the DOL is saying that this will extend the role of a fiduciary to individuals giving one-time advice. So what's one-time advice? Well, that would be anyone meeting with a retirement plan participant and making a recommendation that they roll assets over to an IRA. Part of this is viewed as an extension, which is, well, wait a minute, does ERISA even cover that type of transaction? So it's potentially an extension of that. But traditionally, the fiduciary rule or the role of a fiduciary is only applied to an ongoing relationship. So I think that's the biggest part of this rule that has caught the most attention. So insurance associations almost immediately filed a lawsuit seeking to overturn the rule. So that was done earlier this year. Essentially, their argument is that there's sufficient regulation in place, that we don't need additional regulation. Each state has their insurance commissioners that cover the annuity aspect of it. There's plenty of regulation there. They claim that the rule will actually prevent advisors from providing much needed advice for fear of becoming a fiduciary. And they also argue that the new rule really isn't that different from the earlier rule that was struck down. So this case was filed, like I said, very quickly after the fiduciary rule was announced. The fiduciary rule was supposed to go into effect September 20th. But right before that, the federal judge in the case issued a preliminary injunction barring the rule from taking effect, stating that he believes plaintiffs have a strong likelihood of prevailing. So that essentially meant that the nationwide, the fiduciary rule as currently written is not in effect until this case is decided. So the next stop at the courthouse for the Department of Labor was the ESG rule. So let's just quickly talk about that was issued in 2000 or last year, actually, 2023. Real quick, what is that rule? Well, the rule states that fiduciaries may consider ESG factors in selecting investments, including the default investment options. They also may consider ESG factors when selecting between two similar investments. So that's sort of often known as the tiebreaker rule. And then finally, they may consider participants' non-financial preferences in adding ESG type investments to their plan. Now, as far as the practice pointer here, it remains true. Investment decisions must still be based on the risk and reward characteristics of the investments, which is similar to any other investment offered in the plan. And I think the thing that we always tell people is, you can offer ESG funds, and we have a lot of clients that have a suite of ESG funds, but you really need to make sure that you're monitoring them in the same way that you're monitoring any other investment. So you're not giving them any sort of preferential treatment. The other thing relative to this rule that I've always said is, the ESG rule can change depending on who is in the president's office. So there was a previous ESG rule that was far more strict than this that was issued under the Trump administration. Now we have this rule. So even for clients that really want to use ESG funds, there are a couple things that I would recommend. Number one, if a client came and said, hey, we want a full ESG lineup, we want every investment in the plan to be ESG focused, I would be reluctant to support that in fears that a new administration comes out with a new rule relative to this and you have to change your whole fund lineup. The second thing, even though this rule does say that you can use ESG funds as your default investment alternative, I probably would not recommend that for really the same reasons. So again, ESG is certainly used in a lot of plans, very popular, gets a lot of asset flows, so people sort of voting with their dollars. But I would generally make sure that you have some other investments available as well. So I said this one got challenged as well. 26 Republican state attorney generals filed, it says a lawsuit, they actually filed 2 lawsuits challenging the legality of the ESG rule. One of the, they did do some venue shopping and ended up in the Northern District of Texas, which was considered to be a very favorable court for these Republican state AG's opinion. But somewhat surprisingly, the judge in the case actually dismissed it, saying that there are really 3 factors, saying that ERISA on its face doesn't forbid the use of ESG factors. So there's nothing in ERISA that says you can't use ESG factors. The rule doesn't subordinate the financials, or that doesn't subordinate ESG to other financial considerations. And finally, it's optional. So, based on those 3 things, the court said, I think the rule stands up. The attorney general's appealed it, and it has been pushed back down to the court for further review. So essentially revived the case. So it was dismissed, but it's been revived. A second case focusing on ESG, which is really an interesting one, is the Spence versus American Airlines. So the DOL isn't involved in this one, but this is a case that was filed about a year ago. The initial claim, when filed, the pilot in the case said, hey, American Airlines, you're using ESG funds, and I was negatively impacted by returns resulting from that. It was sort of a weird case, though, because American Airlines said, well, we don't have any ESG funds in our main lineup. And in addition, we have a self-directed brokerage account, but you, Mr. Pilot, don't appear to have any of those. So you don't have any ESG investments. So not sure what's going on here. The plaintiff was given the opportunity to amend their complaint. And what they came back with was a pretty interesting argument. What they came back with, they said, American Airlines, your investment committee has taken into considerations American Airlines policy, overarching policy relative to ESG in selecting a partner to work with this retirement plan. Specifically, what they said is you have selected BlackRock Investments, and we believe that BlackRock uses ESG criteria in all aspects of their ESG investing, in all aspects of their investing. So it doesn't matter if there's an ESG stated fund. In general, all the funds you have in here have ESG considerations taken into account. Now, this case does appear to be going to trial, which personally I'm a little bit surprised. I don't really like these cases. It's not really settled in the investment world that ESG investing hurts overall returns. In fact, I think you can make a strong argument that in some cases it helps your investment returns. I mean, if you're investing in companies that are socially responsible and have strong governance, over time that might lead to better returns. So it's really difficult for me when I see these cases that are focused on unsettled principles, even among the investment world. But it does appear that this one is going to move forward. So we'll continue keeping an eye on those. The final case that we added just recently is this Loper Bright Enterprises case, known more popular in the trade articles and things like that as the case that overturned the Chevron Doctrine. I'll turn it back over to Candace to talk a little bit about what the Chevron Doctrine is, what it's replaced with, and how it's going to impact federal agency decisions going forward.
Yeah, so, as that first bullet says, and some of you may have been hearing about this because it was kind of a big news when it came out this summer, it was the Chevron Doctrine previously required courts to be differential to federal agencies like the IRS and the Department of Labor and interpreting ambiguous statutes. So the impact of that is the IRS and the DOL that regularly interpret and enforce laws that govern retirement plans. Without the Chevron Doctrine, courts could second guess these interpretations. So as Greg was just mentioning, this will probably have an impact on the IRS and DOL, and especially the DOL's fiduciary rule and the ESG rule. So we're already seeing that being challenged in courts currently. So part of the new decision states, and this was from the opinion, that courts may not defer to an agency interpretation of the law simply because the statute is ambiguous. So there's something actually else out there in admin law that most lawyers learn, which is kind of a really boring class, but under the Skidmore Doctrine is the standard that courts may, so they don't have to, which was the old rule with Chevron, but now it's optional, seek aid from the interpretation of those responsible for implementing particular statutes. So in other words, they can still consider agency interpretations of ambiguous law. Though going forward, I think you can expect an increase in legal challenges to all agency interpretations. So this may result in lawmakers taking more care in drafting legislation to address that ambiguity. So federal agencies will likely have to provide greater details supporting their interpretation with the expectation that they'll have to defend that in court. So if you look at the fiduciary and ESG rules, they're so politically charged that a legislative clarification is extremely unlikely, I think, in this case, which really means that we're probably going to see this bounce around the courts a little bit. And also, if judges begin ruling on the party lines for controversial legislation, I think then almost everything will end up in the Supreme Court. You're going to see, as Greg said, forum shopping, where you'll have, Republicans looking for more red states and Democrats filing in more blue states and having potential circuit splits down the road, which we'll talk about later on in the webinar, that you're going to lead to this question that really strengthens the judiciary and weakens federal agencies.
Yeah, definitely strengthens the judiciary at the expense of federal agencies. But as Candace said, I don't necessarily think that's a bad thing. I mean, it's certainly going to have a big impact on laws that are already on the books, as they clear up some of these interpretations. But as Candace said, I think longer term, if it helps legislators be more clear when drafting legislation, avoiding having ambiguous language, that's probably a good thing. If federal agencies need to take more care in preparing a defense of their position when interpreting things, that might not be a bad thing either. So I think over time, we'll have to see where this lands. So that covers the Department of Labor. Candace was going to cover some information with the IRS, focusing, this is when we focus a little more back on Secure 2.0 and some of those optional provisions. There was some guidance that's come out relative to a lot of that information.
Thanks. So the IRS introduced a pre-examination pilot program back in 2022, and it's now extending that program. So under the program, the IRS notifies the plan sponsor that has been identified for an exam, and the plan sponsor has 90 days to review the plan and correct any errors using one of the IRS approved correction methods. So if approved, then the IRS will end up deferring that. The IRS also issued guidance for long-term part-time employees. So this has been a big one. And to be honest, it just tells you to track long-term part-time employees. So perhaps more significant, though, is the guidance that's been issued in the last 2 weeks, focusing on 403(b) plans. So that guidance clarifies that students who are otherwise excluded under the plan will not be subject to this long-term part-time rules. It also allows for the exclusion of part-time employees, but if an employee in this group does not meet the long-term part-time conditions, that employee must be notified of their right to make that voluntary contribution. So the guidance also makes clear that employees must continue to track individuals in the plan because the long-term part-time status and allow them to fully participate if they otherwise meet the plan's eligibility requirements. So in other words, if you're not excluding employees at all, this doesn't apply to you because of universal availability. If you also are already excluding students, then this doesn't apply to you either, given the new exclusion that was released 2 weeks ago. If you're excluding long-term part-time employees, though, then you need to make sure that you are tracking their eligibility. I think, Greg, I know you recently wrote a blog post on this. Why don't you expand on some of that a little bit more? Because I think this is a big issue.
Yeah, I think it was actually went out today, the blog post. No, I think, Candace, you covered most of it, which is, that's been one of the questions is a lot of 403, so this applies to 403(b) plans, right? And 403(b) plans have universal availability, which generally means you have to give everyone the opportunity to voluntarily participate in the plan. And so I think some 403(b) providers were saying, well, I already have universal availability. How does this work? So, Candace said the key thing there, which is if your plan does not exclude anyone and you're doing universal availability properly, which we hope you are, then this shouldn't apply to you and there's nothing you have to do. And I think to me, that's the biggest takeaway. The second biggest takeaway is absolutely the student piece. We were hoping that students could continue to be excluded. Most colleges and universities really don't even have a system in place to adequately track some of the hours and some of the relationship with some of those student employees. So I think clarifying or making it clear that those individuals, those students will not be subject to this was critical. So I think it was pretty, yes, you're right, Candace, much more substantive guidance than what came out earlier this year.
Thanks. So the last point that we have there, so the IRS also issued guidance for the RMD rule. So Secure 2.0 eliminated the stretch IRA, which is when a younger non-spouse beneficiary was named, then you could continue to defer payments based on their age. So the new rule requires most non-spouse beneficiaries to deplete the retirement account within 10 years. So the issue was when the decedent, the person that had died, had actually already started the RMDs. So in this case, the rule requires that the beneficiary would continue taking those annual RMDs. And the IRS announced 2 different times that this wouldn't be enforced, but now with the final regulation, this really indicates that this actually is going to be truly enforced now and starting in 2025.
All right, and there's quite a bit of other Secure 2.0 guidance. We'll go through each one of these. I think these are all items that we've talked about in the past, but there's just some additional clarification that's beneficial as we think about plan sponsors using some of these provisions. So, Candace?
Yeah, so this was actually a notice that was released, I think, like the last day of December in 2023. And reminder, this is our annual regulatory update. We usually do this now in October, so we wanted to make sure we captured everything. But so the IRS issued guidance for several of 2.0 provisions. And the first is additional information related to plans providing de minimis financial incentives to eligible non-participating employees to participate in the plan. So a couple key points here: can't exceed $250, cannot be in the form of matching contributions. It's only offered to employees not in the plan currently, and the incentives are taxable and subject to withholding. So I think the big reminder here is that it's for non-participants. So and the incentives are only for eligible non-participating employees to incentivize them to participate in the plan. So next up is the exception for the 10% penalty for distributions for terminally ill participants. So this provision was interpreted as mandatory by some practitioners and voluntary by others. But I think it's actually a little bit of both. So plans are not required to adopt this as a distributable event. So that's the optional portion. But if a terminally ill participant has another triggering event allowing access to the withdrawals, the participant can claim the waiver of the 10% early withdrawal penalty when they complete their individual taxes. So additional clarification included more information on what's needed from the doctor for that certification to qualify for that, and that there's no limits on the amount of the distribution. So another provision that needed clarification was the Rothification of employer contributions. I don't know why, but I love that Rothification word and that it was used in the notice. But it allows participants to elect to have employer contributions be made after tax. So it was not clear how taxation of these contributions would be handled and what the employer's role would be. But the guidance did provide clarification that the plan's record keeper will be responsible for reporting that through the 1099-R form. So this should be a relief to some employers interested in adopting this because they shouldn't have to adjust their tax reporting systems for this change. The concern, though, is the potential for the tax surprise on the individual who would elect this option. So taxes aren't withheld at the time of the contribution like voluntary Roth deferrals. So participants may owe more taxes than expected when they receive their 1099 in January. But another thing too, the other thing the guidance indicated was that participants must make the election before the plan year and can change that annually. So it also reiterated that employer Roth contributions must be immediately vested. So plans with a vesting schedule may not want to add this option. Last one, easy peasy. The notices extended the deadline for the amendments related to Secure, CARES, and Secure 2.0 to the end of 2026.
All right, thanks, Candace. That's the that covers the IRS portion. Next we'll talk a little bit about some of the retirement plan lawsuits, and I think we continue to see the plaintiffs' arguments evolve. I think 5 years ago, the argument generally was, hey, there was a lower cost fee or a lower cost share class that you could have offered. You didn't offer it, and so I was damaged because of that. I think a lot of the new arguments are starting to focus more on the products that are offered within the plan. So not just the plan in general, but the types of products and services available. And also they are starting to look a little closer at the behavior of the committee. So what is the committee's decision-making process that allowed something maybe to be added into the plan? And one example of this is managed accounts. So just a quick reminder, a managed account service is offered, typically it is offered as a voluntary add-on service within the plan. So in other words, it's put into the plan, but then individual participants elect to pay an additional fee in order to use the service. And the idea behind it is that, I'm going to sign up for the service. I'm going to obviously give you my age. I'm going to give you the expected retirement date, but I'm also going to give you a whole bunch of other data points. And then the idea is that the record keeper will take all that information and build a customized portfolio among the available investments within the plan that would be more targeted towards my particular situation than if I just used a target date fund. So that's sort of a high level overview. Again, the important thing being though that it's voluntary at the participant level typically, because I think a lot of times it'll be positioned as, hey, it doesn't cost anything extra to the plan. But in reality, you as a fiduciary or as a committee member, you do have fiduciary responsibility for any service available through the plan, even if it's not used that much. And I think the other thing that sometimes committees lose sight of is once that service is available in the plan, you still have a duty to monitor it on an ongoing basis. So you'll want to track the use of it. You want to track how much your record keeper is making in additional fees off of that service. So we've definitely seen a few cases focused on managed accounts. The first one is Ghost versus the Dover Corporation. This one's just sort of a straight up, pretty clean argument, which says, hey, you offered managed accounts in my plan. The asset allocation recommendations that come out of that service really are not that different from the plan's target date funds. And I think this one will probably hinge on what the use of those additional data points is. If people are signing up for the service and not really giving additional data points, the argument's probably pretty strong that really you're only using age and salary, and your asset allocation looks about the same as what I would have had if I just went into my age-based target date fund. I don't know how successful this argument's going to be. The next one, though, I think has much more of a legitimate argument, which is Hannigan versus Bechtel Engineering. Similar situation. They added managed accounts to the plan. But in this case, the employer actually defaulted participants into the managed account service. So everyone went into the managed account service, was subject to the additional fee. And if you think about who your defaulters are, it's typically, usually the people who default are some of your least engaged participants. So it's safe to guess that unless Bechtel was able to provide some of those additional data points, one of the only data points being used to create that asset allocation would have been the age of the participant. And if that's the case, then I'm guessing that the asset allocations probably aren't that much different than what they would have gotten in a target-based fund, but the employer put them into a more costly service that doesn't show a measurable difference. So, even for those of you thinking about adopting managed accounts, it's sort of marketed as, hey, doesn't cost anything to the plan directly. People who want to use it can use it. If people don't want to use it, they don't have to use it. But I think it's important to think about, if I were a fiduciary, I'd be thinking about, before I add this, is there proof that the outcomes are going to be superior to what is currently offered within the plan? And absent that proof, it might be difficult to make an argument for adding the service to your plan. The the other area that we're seeing some litigation focused is on target date funds. I reported on this last year. There were 11 cases were filed against employers using the BlackRock LifePath series of target date funds. The arguments were the exact same in all of these. They said you only used cost. All these employers only use cost as the factor in selecting these funds. And then they showed I think four other target date funds that perform better. Courts have been pretty clear, and they've generally been clear in these BlackRock cases because most of them have been dismissed. Courts have been pretty clear. We're not going to second guess the decision that was made by looking at other results. So we're not going to look back and say, oh, you know what, you're right. These other funds did perform better. One interesting thing there is the types of target date funds that they selected to compare against sort of follow different strategies within the saying this performed better. They were fundamentally different investments that they were comparing them to. One of those cases has continued to survive. The Genworth Financial case did receive class action status. This will be interesting though. Genworth Financial is challenging the rule. They're saying you can't grant class action to all of the employees that you say were negatively impacted because we can prove that some of them had better performance by investing in these LifePath target date funds than the investments that you're saying performed worse. So, this is the one that seems to have gotten a little further, but we're going to keep an eye on that one going forward. The next one, Snyder versus United Health Group, was probably a little more egregious. And this one recently settled, and we haven't seen the monetary penalty yet, but I think it's going to be pretty big in this particular case. So in this case, the plaintiff alleges that United Health Group's committee selected the Wells Fargo target date funds due to the business relationship between UHG and Wells Fargo and did not make that decision in the best interest of participants. It just so happens that the $7 billion that UHG had in the funds made them the largest investor in those investments. And also, coincidentally, Wells Fargo uses UHG as their health insurance provider. Some of the backstory of this, though, is even more damning. They did have an investment advisor. The investment advisor recommended 3 different possible target date solutions to add to the plan, and Wells Fargo was not one of them. The CFO got wind of this and got inserted onto the committee. They continued discussions. Wells Fargo funds were now included as an option, and their investment advisor was not invited to a lot of these meetings going forward. So, the more you looked at these facts, it became clear that they were making corporate decisions, not fiduciary decisions in the best interest of their clients. And like I said, this one just recently settled. I'm waiting to see the monetary penalty because I do expect it to be large. There's a couple more cases here. I put this one in the Sherwood versus Horizon Actuarial, just serve as a reminder to everyone that it's really important to understand and monitor your personally identifiable information. Management of a retirement plan requires large amounts of PIA transferring between organizations. And in this case, Horizon Actuarial actually provided administrative service to multiple retirement plans. They were the subject of a significant data breach. Hackers accessed multiple plans and really got the list of all the PIA that they got was extensive. Again, the case settled for $8.73 million. As it relates to PII, though, I would recommend that people look at the DOL recommendations on how to handle PII. Even have your record keeper come in and introduce how they handle data in their organization. And a lot of times I think committees should be inviting their own IT staff in talking about how they handle data internally as well. So just a reminder of the care and concern and how much of that information does transfer. The next one is sort of the newest flavor of litigation that we're seeing, and this is the use of forfeitures. And this one started to pop up as individual cases that we're seeing, but now what we're seeing is even a lot of the existing litigation they're slapping this forfeiture claim on onto their existing claim. So basically what this argument is, it says that if you have forfeitures in your plan, you should be using those to reduce the participant cost in the plan. And most employers typically use forfeitures to reduce the company contributions to the plan. Now, this is an interesting case because there is no question under the IRS rules, you absolutely can use forfeitures to reduce company contributions. That's always been a longstanding rule. So, what the allegation here is, though, they're saying that the use of forfeitures, that's a fiduciary decision that you're making. So the fact that one option is to reduce company contributions, if it's indeed a fiduciary decision, the other option, which is to reduce plan expenses, benefits the participants. So if it's a fiduciary decision, it means you have two options. You can do either one, but one of them is in the best interest of participants, and one of them is in the best interest of the organization. If this is indeed a fiduciary decision, you need to make the decision that's in the best interest of participants. I have it highlighted here that these cases may hinge on a determination of settler or fiduciary functions, because the employers would say, well, wait, that's not a fiduciary decision. That's a settler decision that I can make as a business owner, and I choose to have it go. I choose to reduce my contributions. If you look at plan documents, a lot of them are fairly ambiguous, and they say that you can use forfeitures for either. So we're definitely going to be keeping an eye on these cases. I think if you're wondering, if you're concerned about this, I think as a plan sponsor, there's some considerations here. How are forfeitures currently being used? Is your policy consistent with the plan document forfeiture rules? And do documents need to be amended to provide a hierarchy for the use of forfeitures? So in other words, sort of hardwire into your plan document. They're first going to be used to reduce company contributions. They're second going to be used to reduce fees. I don't think we're there yet. If someone said, do we need to go out and amend our plan document? I don't think we're there yet. Also other sponsors that are saying, well, how concerned should I be about myself getting sued? Just a couple things to think about here. The first one of these cases that got filed, I think it was Mattel. The allegation was that there was over like $11.5 million in forfeitures. And I was like, whoa, how do you get $11.5 million in forfeitures? I mean, the only way that can happen is if you probably have, well, first you have to have a ton of employees, right? Second, you have to have a vesting schedule. And third, you probably have to have fairly high turnover so that a lot of unvested balances are moving over to the forfeiture account. Now, I can tell you, luckily for me, I do a lot of work in the nonprofit space. Most college and university plans don't even have a vesting schedule. So the only way they really get forfeitures are sort of administrative errors that put a relatively small amount of money into the forfeiture account. So, generally, if you don't have a ton of forfeitures, I don't think this is something you need to be worried about right now. I do think as these cases move through the courts, though, I think the outcome will be that maybe we'll find out that we do need to sort of hardwire the plan with a hierarchy of how we're specifically going to use those forfeitures. So the next item is Supreme Court review. Well, I'll just let Candace talk about this. The Supreme Court review, there's a couple cases, but there's been some splits between some of the circuit courts. I thought this AT&T case was going to be the one that found its way to the Supreme Court, but the Supreme Court just recently accepted review of the Cornell University case. So Candace, can you give an update on sort of what's going on there?
Yeah, so in April, AT&T filed a petition to SCOTUS to review the Ninth Circuit's decision that ruled that fees paid to the record keeper from Fidelity for brokerage and managed account services was a prohibited transaction, which is kind of ridiculous. So this was brought before SCOTUS because other courts kind of had a different view that the fees paid for services in the plan was not prohibited transaction. So SCOTUS has yet to grant the petition to review this case, but it was remanded back to the lower courts to determine if the statutory exemption under ERISA applies for these transactions. So on the other hand, we have this Cunningham versus Cornell University case, which just came out October 4th. So this isn't in the published regulatory update that we put out. But we do have a blog post. SCOTUS actually granted petition to review for this case, which dealt with also with prohibited transactions. And here we kind of have the opposite end of the spectrum with the Second Circuit that held that prohibited transactions claim can move forward if the plaintiff alleges that the services provided were unnecessary or that the compensation was unreasonable. So completely different thing. You have to allege, the plaintiff has to allege a lot more for the case to move forward. So SCOTUS's decision to review this case is based on kind of the different flavors that we've been seeing in the different circuits. So a few of those flavors. So first we'll start with the Ninth Circuit from the AT&T case, which is really the Eighth and the Ninth Circuit. So those complaints were allowed to proceed as long as the plaintiff alleged that the transaction occurred between the plan and the service provider, which everyone has going on. So that was really interesting to see. This is kind of definitely the most lenient of the three flavors that we're seeing, and it didn't require additional allegations of harm or improper conduct and focused only on the transactions really meeting the technical elements of ERISA's prohibited transactions rules. The Third, Seventh, and 10th Circuit are really more of a middle ground, and they place a greater burden on the plaintiff by requiring them to show not only that the transaction took place, like the Eighth and the Ninth Circuit, but that they also benefited from the service provider due to that pre-existing relationship or that there was self-dealing. And then last, of course, is the Second Circuit that we just talked about. So that case really emphasized more that the plaintiff shouldn't be allowed to proceed without first establishing some basis of a really suspicious wrongdoing. So if the Cornell University case is affirmed, then this probably would potentially limit future prohibited transaction litigations. I think what might be happening here, though, which we've seen in the past, is they might end up combining these two since they have yet to decide whether they're going to review the AT&T case, since these both are kind of really similar to set a single standard.
Yeah, the only thing I'd add on the AT&T one is, so the appellate court looked at it and said, yep, this is a prohibited transaction, sent it back down to the lower court. That doesn't mean that AT&T loses. So, there's still going to be a review. And so it revived the case, but then the question back to the lower court is, okay, we've told you it's a prohibited transaction. There's certain exceptions that allow for prohibited transactions. Now you need to review the case again and determine if one of those exceptions applies. So just because it got remanded back down and just because it was deemed a prohibited transaction doesn't necessarily mean that AT&T is going to lose. All right, so we're going to finish about right on time today because the last slide that we have is focusing on defined benefit plans. I'm sort of taking this full circle, right? We started today talking a little bit about sort of the changing landscape of retirement savings. And one of the big reasons that the landscape has changed is because people aren't retiring with defined benefit plans in the same way they used to in the past. So they're more dependent upon their own personal savings. And one of the trends that we're seeing relative to defined benefit plans is that many employers have frozen their plans to new participants, but they still have a responsibility to manage that plan on behalf of all those people who entered the plan previously and are entitled to benefits from that plan. So a lot of employers are looking for ways to minimize their risk. Because if you think about it, if I'm an employer, I have a DB plan, I am holding on to the longevity risk for all those people in the plan. So if they're living longer, as an organization, I'm going to have to make sure that that defined benefit pension plan is funded to satisfy those claims. So there's a couple things that employers are doing to try and de-risk their plan. The first, they usually do both these steps. The first is they often offer a voluntary payout. So you just go to the existing DB plans and offer a present day cash value of their future benefit. And again, this removes the longevity risk from the plan and shifts it to the individual. That's usually the first step. So you do that, see how many people voluntarily leave. And then the second step is called pension risk transfer. And in this case, the employer purchases a lifetime annuity from an insurance company on behalf of the employee. So in this case, you're shifting the longevity risk from the employer to the insurer rather than to the individual. But both of these result in shifting that risk away from the employer. This has been happening quite a bit. And again, like I said at the beginning, not as much about regulation, but about litigation. There have been at least 4 cases filed for these pension risk transfer scenarios, and in all of these cases, the same insurance annuity provider was selected. It's Athene Annuity as the annuity provider. Plaintiffs allege that the selection was made based on the cost of the annuities and not on the future claims paying ability of the insurer. So, we're sort of conclude with what I think has been the theme throughout this entire conversation today, which is, being fully aware of the fiduciary decisions that you're making as a committee and as an employer, and understanding that they always must be made in the best interest of your participants. And as it relates to these DB plans, the claim is that the insurer engages in risky investments that could negatively impact future returns and therefore negatively impact the future claims paying ability of the organization. So even when you're selecting a partner, you do have a responsibility to make that decision in the best interest of the participants. So that's really what we had. We only have a minute left here, so there is a question. Let me read this real quick. Oh, there's a question. Okay, so there's a Secure 2.0 provision about increased catch-up contributions for ages 60 to 63. I'm not going to be able to give this question the full answer that it probably deserves, because I think there's some ambiguity with this particular provision as well. The question says, are you seeing any clients adopt this provision, and do you have a recommendation? I believe there's still 2 schools of thought on this. One of them is that if your plan offers age 50 catch-ups, you automatically have to allow age 60, 63 catch-ups. So it's not a question of adopting it. It's a question of, if you have age 50 catch-up, then this is available. I think we still need some clarity on whether or not that's the case. Another question related to student eligibility. This probably goes to the long-term part-time guidance that we just talked about. There are a lot of employers that have an exception for students. So students are specifically not included as a participant in the plan. That means they can't do voluntary contributions, and they don't get to participate in the employer contributions. There was a lot of concern with these long-term part-time rules. Again, the long-term part-time rule says if you work over 500 hours in 2 consecutive years or 2 consecutive periods, you have to be given the opportunity to make voluntary contributions to the plan. Employers often don't track students the same way they do other employees, and this was becoming a big concern. And so the recent guidance said that if your plan currently excludes students, they do not have to be subject to the long-term part-time rules.
I think too, as I think we mentioned earlier, there's also a blog post. So if you go on Multnomah Group's website and go to blogs tab, that blog post was just released today. So if you want some more information on that, that just came out.
All right, so I think we've covered all the questions, and we're right at 11:59. So thank you everyone for your attendance today. If you have any other questions, please reach out to me, Candace, or your Multnomah Group consultant, and we'll be sure and get an answer for you.
Thank you.
Have a great day.